Legal analyst Ivan Golde with some insight into stories we're following, and we're finding out now that an important decision is coming down from the state Supreme Court regarding same-sex marriage. It'll be heard just after Labor Day. And it's really not about the issue itself. It's about really if the backers of Prop 8 can defend it in court.
If the proponents have the legal authority to bring this lawsuit, the sponsors of this initiative. Remember, this initiative was ruled unconstitutional.
By Von Walker.
Correct.
But in that lawsuit, the defendants were then Governor Schwarzenegger and then Attorney General Jerry Brown. So they were sued basically over Proposition 8. It was defeated, declared unconstitutional, and then they went back and said, we're not going to appeal. We don't want to defend
We don't want to appeal. Yeah, it's a political hot button. They didn't want to get in the middle of it. Remember, the proponents of this wanted to ban same-sex marriage. Arnold Schwarzenegger and Jerry Brown on that issue favor same-sex marriage, so they didn't want to appeal it. So then the proponents, the sponsors, want to go into court directly, and the court is saying, hey, look, you guys aren't the Attorney General, you're not the Governor, what are you doing here? You don't have standing. And they're saying, yes, we do, and the judge is saying, show me, because under state law, you do not have standing. Only the Governor and the Attorney General can appeal this, and you're not the Governor and the Attorney General, But then the court is saying, look, I'm not positive. We're a federal court. This is a state court issue. I want some guidance from the California State Supreme Court. So the argument's going to be on September 6th, do they have legal standing? And that's where the briefs, the case file will all go to that issue. And the thing is, Mark, this could open up a Pandora's box. This thing is going to potentially take the authority away from the Governor and the Attorney General. I'm not sure the courts are going to want to do that. I'm not sure the state law will allow that. This thing could get appealed, go to the California Supreme Court. And you know what? Oddly enough, this case may not stand for same-sex marriage. This case may be new case law for standing for proponents of these initiatives. Ironically enough, that's where this thing could be going.
So ironically, this could get to the U.S. Supreme Court, but not on the issue of same-sex marriage, but instead on the issue as to whether or not they even have standing to fight
And if the court rules they do have standing, then they would go back and argue the substance of the case. But you're right, it could go to the U.S. Supreme Court on the standing issue. So there's a lot of litigation that's going to come forward.
Now, if there's no standing here, if they can't defend, the proponents of Prop 8 defend it, will same-sex marriage be allowed to happen?
Well, this initiative, the legs would be cut out. That would be it. Same-sex marriage then would be constitutional. No standing. You never hear the merits of the case. It's over. The federal court decision will stand. Why? Because the Attorney General and the Governor will not appeal. Now, perhaps in the future, then another Governor or Attorney General may want to appeal, and that would be a different story. Or maybe another initiative down the road may come on the ballot in a different political time, different judges, different governors, different Attorney Generals, and maybe a different result. But for now, if the court throws this out based on lack of standing, that's it. The ball game's over.
All right. So if it is unconstitutional, at that point it stands. Can you put another ballot measure forward, even though it's unconstitutional?
Absolutely. A different measure. You can tweak it differently. You can word it differently. And remember, these are judges. These are human beings who make these legal rulings. Maybe a different judge in a different political climate in a different time may disagree with the previous judge and may find it constitutional. That's why constitutional law is always changing. The laws change, the writing, the ballot initiatives change, and the judges, they rule differently. It could be the same issue, but they rule differently. They just disagree. Most U.S. Supreme Court decisions are close, very close. So reasonable minds can differ.
And this is something we'll probably be talking about even 3 years from now.
Probably. It'll be in the courts for a long time.
All right, Ivan Golde, thanks for joining us. We'll have you back here next Friday, and we'll be right back as the KRON 4 Morning News.